Hello, hello, hello. You are here with Dave Jose. This is 5 Minutes to Freedom, and we're on video number 11. The title is To Court or Not to Court. We are going to release some heavy deception. Let's go. Now, for many of you guys, you wonder if these vaccines that they're talking about forcing, the COVID program and lockdowns and mandates and CPS, where they're just taking kids all across the nations. Sophia Zori posted about a case out of the country yesterday where a judge said that because somebody did not wear a mask or follow a mandate or something of that nature, a parent was allowed to have their child taken. And they were doing this inside of a family or juvenile, what they call a court. Now, my question for you guys, with all these mandates, with all these executive agencies, with all these different things that we are seeing happening, are we really being brought into courts, or would the government ever deceive us? We're going to go deep into some knowledge that most people will never hear, most lawyers will never teach, and in the process, they will steal more property from you, more wealth, and more of your rights than any other time in history. You got to see this. Let's go deep. Okay, so what we're going to look at is United States versus Meeker, 350 U.S. 179, 1956. Now, in this case, a man was called before an administrative officer by subpoena. Now, guys, I want you to realize that there are a lot of executive branch subpoenas and notices and citations being sent out, but have you slowed down to stop to see if these are actually judicial proceedings, or is the court trying to, or the entity trying to trick you? Now, here's where to get funny. My schooling is in psychology, and I can tell you that right now, some brainwashed and some programmed people will start to say, come on, Dave, what do you mean the court trying to trick you? They're the government. That wouldn't happen. Okay, so let's look at Section 235A of the Immigration and Nationality Act of 1952 and what it provides. Any immigration officer shall have power to require by subpoena the attendance and testimony of witnesses before immigration officers relating to the privilege of any person to enter, re-enter, reside in, or pass through the United States, or concerning any matter which is material and relevant to the enforcement of the act and the administration of the service. So let's see what this case held. This section does not empower an immigration officer to subpoena a naturalized citizen who is the subject of an investigation by the service to testify in an administrative proceeding before such officer where the purpose of the investigation is to determine whether good cause exists for the institution of denaturalization proceedings against such citizen under 340A, so on and so forth. All right, pay close attention, guys. This statute is kind of worded funny, but it doesn't give power to an immigration officer to subpoena somebody who's a naturalized citizen or subject to an investigation, or to bring them before an administrative hearing officer, which is not a judge. So if somebody is taking you before someone who's not a judge, but tricking you or making them wear certain clothes or making them give documents that look like it's an order when it's not, is that not deceptive practices? Now it's going to get deep because I got a good friend in one of my groups, and as I said, Sophia just put out something about a administrative law guy calling himself a judge in a family court or juvenile court trying to take a kid over something with not doing something with COVID. But guys, these people will subpoena you or draw you into a hearing or write an order for you to go into a hearing, try to figure out if they should take your child in an investigation, but it is not a judicial hearing. So what's happening is an administrative branch agency is forcing you to do something under deception that you don't have to do. If it's not a criminal case, why are they making it compulsory for you to come in and telling you you have to tell something, or you have to speak up and give them this information that they want? All right, let's dig more into the case. Powers sought to be exercised that make for a restrictive reading of this genus-faced word witness. The subpoena power is a power capable of oppressive use, especially when it may be indiscriminately delegated and subpoena is not returnable before a judicial officer? Guys, is the court, the Supreme Court, trying to tell you that sometimes someone will give you a subpoena and then is not returnable before a judicial officer, but only an administrative agent who can't hold a court with no judicial proceedings? All right, now look at this. True, there can be no penalty incurred for contempt before there is a judicial order for enforcement, but the subpoena is in form an official command, so they're tricking you. And even though improvidently used is not correct, it has some coercive tendency either because of ignorance of the rights on their part of those whom it purports to command, or their natural respect for what appears to be an official command, or their natural respect for what appears to be an official command, or because of their reluctance to test the subpoena's validity by litigation. I don't know if you guys caught what that meant, but what it means is that the people are deceived into believing that it is a real subpoena before a court, and because they don't know, they don't take it to a real court and fight it, so they're just abused. Wake up, my people.